Yes. No, you look just like I remember you.
Well, that's good.
Yeah. Not much changed, but I appreciate your time giving me a chance to interact with the students and their teacher. Ms. Livingston, I see you are back.
Yes.
And I see Ms. Loray's tile, so I assume she is back. Mr. Goldberg, are you ready to we're going to get back on the record in a second. Are you ready to go?
I am, Your Honor.
And Ms. Livingston, are you ready to go?
I am, Your Honor.
All right, Mr. Almakinder, if you get us back on the record, please.
Yes, Your Honor. We are back on the record. The time is 12:48 p.m. Thank you so much, Your Honor.
You're welcome. So we paused after Mr. Goldberg had responded to Ms. Livingston's argument as to why summary judgment was appropriate to the Fair Housing Act discrimination claims. And you had asked Ms. Livingston whether you'd be able to respond to, I guess we call it a reply to his response, which you can do now briefly. And then I'd like to hear your presentation about the retaliation piece.
Your Honor, when she finishes, could I just have 1 minute? Because I found some of the record sites of questions you asked private.
Why don't we, okay, we're going to get on the record, but we'll start with what you've got, Mr. Goldberg, and then we'll go back to Ms. Livingston.
Okay.
Oh, we are on the record. That's right. He said 12:48. So why don't you start, Mr. Goldberg?
Your Honor, at page 28 of Mr. Leslie's deposition, he was asked how long after he had moved did he give the dog away. He said, I don't remember how long, but it was a while. The question was, so a few months? He said, yes, it was more than a few months. And then he said that he had to give that up because he couldn't find anybody to take care of it. At page 32, he said he was unable to work. And at page 82 to 83, he talked about how they had shut him off from being able to pay rent. And he gave that testimony in June of 2020.
I don't understand the last point. Shut him off, meaning he tried to pay rent on June 1 or 2 of 2020 after he was supposed to leave per the court order. And he observed basically what Ms. Livingston told us, which is that the apartment complex said, we don't want your money. You said you were going to leave. You need to leave.
Your Honor, they certainly said, we don't want your money. You said you're going to leave. You know, and he didn't leave. I'm not going to say he didn't, but I am saying that he tried to make his November and January payments. I'm sorry, December and January payments, and they wouldn't let him pay through the kiosk, whatever you want to call it. And then at that point, they wouldn't take any more payments. I mean, they wanted him to leave. There's no doubt about that.
Yeah. Okay. Got it. Thank you.
Your Honor, before we leave that point, I want to clarify, as I showed you the ledger earlier, Mr. Leslie was able to pay his rent online on the 15th, which he did. They were returned as non-sufficient funds. So there was at no time during his active lease agreement with the defendants that he was ever cut off from being able to pay rent online.
No, I didn't hear Mr. Goldberg say that. I thought he was referring to efforts to pay on or after June 1, 2020.
Oh, I apologize. I believe his last statement, I thought he had said December of 2019. I wanted to clarify that.
No, he did. But as I understood it, what he was saying was, look, Mr. Leslie was trying to pay that back rent after June 1, 2020, but he couldn't because his term was locked out. He wasn't able to get money to your client after May 31st of 2020.
I see. Okay.
Yes, Your Honor.
All right. So Ms. Livingston, anything you want to say in response to Mr. Goldberg's arguments as to why I should not grant summary judgment on the FHA discrimination claims, and then let's move to FHA retaliation.
Absolutely, Your Honor. Ultimately, the plaintiff must present a prima facie case for fair housing discrimination. If he does not, that is grounds for summary judgment. There are no issues of fact that the jury needs to consider. It is a question of law whether Mr. Leslie proved the 4 elements of the test that's presented in numerous federal cases that both Mr. Goldberg and I have cited. At the end of the day, Mr. Leslie has not proven that the defendants ever refused an accommodation, especially with relation to the reasonable accommodation for the late payments It's an undisputed fact that the defendants did grant that accommodation. It's an undisputed fact based on the ledger that those late fees were revoked and he was allowed to pay rent late. Mr. Goldberg, I believe, is confusing the issue by bringing up automatic email notifications from management that are sent to all tenants after the 3rd of the month stating your rent is now late, you must go ahead and log in and pay. Even if Mr. Leslie was receiving those, that was not the accommodation that he would be able to pay rent late without receiving automatic emails. The accommodation was he could pay rent late without incurring late fees. And the record is undisputed that that is what he was allowed to do. The ledger shows that late fees were revoked and that he was allowed to pay by the 15th of each month. Therefore, he does not uphold his burden of proof in presenting a prima facie case because he has not proven that defendants refused that accommodation. Secondly, Your Honor, and this goes to both the accommodation for payment and the accommodation for service animal, plaintiff has not proven the second prong of this test, the third prong of the test, which is that the accommodation must be necessary to afford the plaintiff an equal opportunity to use and enjoy the dwelling. There are absolutely no medical records within the record evidencing his necessity for an accommodation to pay rent late or for service animal. Instead, Mr. Goldberg presented as evidence only Mr. Leslie's affidavit. Mr. Leslie is not a medical practitioner. Mr. Leslie did not present any statements from a medical practitioner who could diagnose his need for a service animal or to pay rent late. So there again is no evidence in the record proving what Mr. Leslie must prove, the third prong, that there be a necessity for the accommodation to ameliorate the side effects of his PTSD.
Was there anything in the universe of attachments that prompted your motion to strike that would constitute medical evidence of the necessity for the accommodations?
Well, there is a question to that, Your Honor. The only piece of evidence from someone who's licensed was from a therapist, and that was the attachment to the evidence we're asking be stricken. Again, it prejudices us at this stage because we would have deposed that individual. We would have determined if they were a medical expert who could opine to that issue to prove if there was necessity for the disability. We can't do that at that point. And of course, they were not a medical professional or a nurse or an MD. It was just a licensed therapist. I believe there was no real, it was only one letter, so we can't be sure exactly who the practitioner was. But that's the only piece of evidence presented.
Okay, well, but then it takes on added significance if that's the one thing that you think might get in the direction of evidence beyond Mr. Leslie's lay opinion about what's necessary. But then it's the subject of the motion to strike. So, all right, I will take that under advisement. Let us shift to the retaliation claim. Come on up.
Absolutely, Your Honor. I'll go ahead and share my screen again.
Familiar, same guy?
Yeah.
And Your Honor, are you able to see my presentation?
There it is.
Okay. I'm trying not to rely too much on a presentation. I know that you have a very good understanding of the facts in this case. So moving on to the retaliation claim, plaintiff did also fail to present a prima facie case for retaliation under the Fair Housing Act. As we stated within our brief, there are 4 elements as well to a retaliation claim under the Fair Housing Act. The plaintiff had to have engaged in a protected activity, that the defendant was aware of the activity, that the defendant took adverse action against the plaintiff, and that there was a causal connection existing between the protected activity and the adverse action. As you pointed out correctly earlier, Your Honor, protected activity is something that needs to be defined within the scope of this test. And it's defined in Wilson versus Wilder Balters Partners, Inc., and again in the Second Circuit in 2000, which is cited here. Protected activity under the FHA refers to action taken to protest or oppose statutorily prohibited discrimination. And these type of actions include filing of complaints, protests such as letter writing. It has to be anything that's lodged in protest of a statutorily prohibited discrimination. And again, it is the plaintiff's burden to allege facts to support that they took these protected actions. These actions are defined by the FHA, and case law has defined them as it has to be something such as filing of complaints, letter writing, something to the effect of rejecting discriminatory action. We cannot pick and choose what type of actions are protected actions, as the plaintiff is attempting to do in this case. Based on plaintiff's own complaint and Mr. Goldberg's arguments today, they claim that their retaliation argument is based on maintenance requests for the lock to be repaired. Suddenly, Mr. Goldberg today is arguing that the retaliation was because of a protected activity to request a reasonable accommodation. But again, that's not even connected to what a protected activity is. And as you pointed out earlier, Your Honor, it has to be causally connected. The retaliation has to be causally connected to those protected activities. So even if this court determines that a maintenance request, the reasonable accommodation are protected activities, the evictions were not causally connected to that. The proof, as put forth by the evidence and in the record, is that the evictions were attached to the late payment of rent and the defaults. Two defaults in rental payments that plaintiff consented to and agreed to in writing from both of those eviction hearings. Plaintiff admitted that he was in default both of those instances, and the evictions were based on defaults. They were not based on retaliation for maintenance requests and for reasonable accommodation. So again, the plaintiff has failed to prove his case for retaliation because there's no evidence that the plaintiff engaged in FHA protected activities, and there's no evidence that the evictions were retaliation for those protected activities. And we again request summary judgment on this issue.
Can you go back one slide, please?
Sure.
I was looking for Wilson is the name of the slide. I was looking for Wilson in the body of the slide. Like, I don't see it. I don't see it. So there it is. No, it's all good. It's the really big letters that I should have been looking for. Okay. And again, we've got a case that's from a district court that is not the district in which we reside. But your point is what Wilson stands for is these are what the elements are. It's not proposing an obscure sideline principle of law related to FHA retaliation actions. It is sort of saying, here's what a claim must do. And so it's the kind of case that would be cited elsewhere for a basic principle of law as opposed to controlling authority.
Absolutely, Your Honor. And again, it's also quoting a Second Circuit as well, which is discussing the elements that all federal courts look at for this claim.
Okay, got it. Thank you. Mr. Goldberg, what I pressed you on today was what's the protected activity? Your answer was two things. Protected activity number one was Mr. Leslie requesting rent accommodation, and protected activity number two is Mr. Leslie requesting a service animal. Those may well be things that are defined somewhere in federal law as protected activity, but that doesn't seem to be what we're focused on here, meaning under the law as Wilson describes it. What is Ms. Livingston missing, or what am I missing? Because we seem to be talking past each other, the two sides. Defendants are saying, look, there was no protected activity involved. I mean, the protest or the opposition to this alleged discrimination is bringing the lawsuit, in which case the chronology is all backwards, because any retaliatory steps that the defendants took, and they may have taken all sorts of them, they couldn't have been in retaliation to the lawsuit, because the lawsuit, which would be protesting the discrimination, occurred after all of the alleged misdeeds. So how do you reconstruct the chronology so that it works?
Well, Your Honor, I don't accept her analysis to begin with, and I refer Your Honor to a case called Dixon versus Hallmark Companies, 627 Fed 3rd 849 at 858, an 11th Circuit case.
Can you give me the site again, please?
627 Fed 3rd 849, 11th Circuit. Now, Your Honor, it is unlawful. Let me see if I can phrase it this way. the statute provides it's unlawful to discriminate against any person in the terms, conditions, or privileges of sale or rental of a dwelling because of disability. And the court says to establish a claim for retaliatory housing discrimination, the plaintiffs must assert that the defendant coerced, intimidated, threatened, or interfered with their exercise of rights under that statute. And that's what they did. In other words, he was exercising his rights. He wanted accommodations. In response, they retaliated against. The Georgia Court of Appeals in Bailey versus Stonecrest at 304 Georgia Appeals 484 wasn't discussing retaliation, but they talked about how you could prove something by suspicious timing. Well, immediately after the request for accommodation, all these things start to happen. He keeps getting notices to say, you're late. Now, I call that retaliation. People who are not lawyers and receive notices saying that you are late are not supposed to think that this is a frivolous thing, that he's not late. Why do they keep sending the notices? What is the effect of sending those notices? Those are jury questions. But he was trying to exercise rights under 3604 of the Housing Act. And in retaliation, they took these actions. A district court opinion in the 11th Circuit talks about how the idea of threatening evictions is a retaliatory action. Well, in this case, they repeatedly threatened evictions. You're late. People know what happens when they're late. They get evicted. So that, again, is a jury issue. But again, when she keeps using terms like no evidence in the record, what she means is that the jury would rule for her. We don't know that. There is evidence in the record. And Your Honor, I might note that we talked about medical evidence in support of his claims. Nobody has cited any authority that says that you need medical evidence from an expert to support an ADA Rehabilitation Act or housing claim for disability discrimination. And Your Honor, what this all reminds me of is just a simple negligence case where you're arguing about proximate cause. And the courts have just said repeatedly, except in plain and undisputable cases, the issue of proximate cause is for the jury. And the same thing I would say here. Were these actions the result of what he did in terms of asking for his accommodations? That's a proximate cause question, and that's for the jury.
Well, I still feel like we're talking past each other. So what about the law in Wilson am I missing, Mr. Goldberg? Because that seemed pretty clear that the type of action that is protected from retaliation, it's like a whistleblower. You can't go after the whistleblower. Here, Mr. Leslie would be whistleblowing, if you will. He's protesting or complaining some discriminatory action that the defendants allegedly took directed at him. But there is no, the only protest or complaint I'm aware of, there are many, but you don't want me to think about the other ones. But for the purposes of this case, it's this lawsuit. And that occurs after these acts of alleged retaliation, like assessing late fees, but immediately refunding them, or seeking a dispossessory action based on an actual non-payment of rent. So what?
Your Honor, where you're going wrong is this is not a whistleblower case. The Rehabilitation Act, the ADA, and the Fair Housing Act do not require you to be a whistleblower. They require you to engage in actions that are protected by the Fair Housing Act, such as
so I hear you, but stop. Thank you. I hear you, but This is why I was a little confused when you recast the landscape and said, no, the protected activity was requesting a service animal or requesting rent accommodation. That, of course, is the basis for your discrimination claim. Hey, we should have received these things and we didn't. We were discriminated against. What's the, I don't understand the retaliation. I guess that's what it's the same thing triggers both claims. How are you discriminated against and retaliated? Either you got what you asked for or you didn't.
Your Honor, I think I would say the following. It is not unusual to have two different statutes cover the same conduct, okay? But in this particular case, what we're talking about is this. And I don't agree with you about part of it, but let's use it on your terms, okay? The retaliation in terms of the storage area. The question is, why did Mr. Hurd, who told Mr. Leslie he was going to look into the matter, flat out not look into the matter? There's a reason for that. And the reason I think it is retaliation.
Retaliation for a request to have a service animal or a request that was already granted to pay rent later than others.
Your Honor, the timeline is not quite so clean. It is Mr. Hurd is dealing with Mr. Leslie and he doesn't like it. And he keeps having to change letters that he sent out because of Mr. Leslie's request. I gave you one of them. Sorry, I had to revise the letter. When he gets the request to go to the storage area, what's the first thing he does after he goes to the storage area? He goes back to the office to look up whether or not Mr. Leslie even has a storage area. I mean, he's taking these actions against Mr. Leslie because Mr. Leslie is approaching, as far as he's concerned, the pain in the ass status. People who demand their rights are pains in the ass. But that's what Mr. Hurd is thinking. But he's taking these actions because he's been steadfast in asking for his accommodations. The deposition page that I told you before says that he repeatedly asked about the dog and he never got an answer. But he's engaging in protected activity, and the question is, what are they doing in response? Why, for example, why does he get a notice every month that says you're late? And why isn't that retaliation? Now, it may not be, chopping off your hands, for God's sakes, but it's certainly not something that you want. And I'll just put it to you this way. I'm sure you would appreciate it if every month the credit card company you had overcharged you $500, then a few days later said, sorry, here's your $500 back. And that happened month after month after month. The fact that they returned the money is kind of irrelevant.
It happened twice, is that correct? Or is this supposedly confusing timeline that it happened month after month after month? So you just there said 3 months. My understanding is it happened twice. Was it more than twice? Am I missing something? Or
Your Honor, in his affidavit, he sets out a number of times that it happened. And the check.
I'm talking about while this defendant controlled the property.
Yes, Your Honor. Your Honor, give me 1 moment.
So I don't have his affidavit in front of me. Why don't you walk me through that?
And that's what I'm trying to find, Your Honor.
But you got to be
quick.
So I've got it now. It's a 25-page affidavit.
Yes, Your Honor. Oh.
I'm not seeing it. It's not a 20. I mean, there are all sorts of attachments, which I guess are of course, the copy I have is not signed or notarized. I trust there is a signed notarized one out there, because it's an easy way to resolve this affidavit if it's not signed and notarized. But I am not seeing where in his affidavit he sets forth a set of circumstances that is consistent with what you're saying.
Your Honor, hold on one second.
May I also ask which exhibit we're looking at, Mr. Goldberg?
I'm sorry.
I'm sorry, which exhibit are we looking at?
I'm looking at his client's affidavit. He said in his affidavit, Mr. Leslie, my question was, where are all these months of these mistaken, erroneous late fees assessed? Because in what I saw during Ms. Livingston's presentation, it happened twice and they were immediately refunded. And Mr. Goldberg on several occasions today has said month after month after month. That's already 3 months, but the notion is that it just was ongoing. And I asked where in the record that evidence is. And he said, Mr. Leslie's affidavit, which I'm looking at, and I don't see it in there.
Your Honor, let me give you the citations. Okay. At page 47 of his deposition, he said they charged me late fees that I was not supposed to be charged on October 15th, 2019, but there were other times after that. And at his affidavit in paragraphs 21 and 23 is where he sets that out. The late fee was $122.77, which he says at his deposition 71. And he was charged a late fee in December, which he says is 74. They did it in October 2019. Exhibit 8 to her deposition at 36. They did it in November 2019, Exhibit 9 to her deposition at 35. And Mr. Hurd discusses this at 38 to 42. And Mr. Hurd admitted that he sent out demands for late fees after accommodation was supposedly granted. So that's what I'm referring to. And I'm talking about, Your Honor, I cannot find his affidavit at this moment. I apologize, but I'm talking about the citations that I have in my response to their summary judgment at pages 6 through 8 of 24.
Okay. All right, I need to hear from Ms. Livingston because I'm frustrated by this talking past each other. I understand what Mr. Goldberg is saying. He's saying, look, it is clearly protected activity to be able to seek a reasonable accommodation. And it sounds like it could qualify as retaliation if the recipient of the request, instead of granting it, or even after granting it, tries to make life difficult for the requestor. That seems like it would be retaliation. But this case, this Wilson case, only looks at you have to be protesting or complaining or fussing about something. Are you saying, well, I'm not understanding why the case law isn't clear about this. Are you saying it is not retaliation if the fact pattern is plaintiff says, could I have a reasonable accommodation, and defendant, instead of granting it, or maybe even after reluctantly granting it, says, well, we need to do something about this guy because that's expensive for us. So we're going to make it cold in his apartment or not let him park his red Jeep Cherokee in covered parking, all in retaliation for the fair exercise of rights under the Fair Housing Act?
No, Your Honor, the law is very clear. Just because plaintiff had a perception that defendants acted in a way that he wasn't happy with does not mean that it is legally a basis for retaliation under the Fair Housing Act. The law is very clear that retaliation are actions taken against, in this case, a tenant who would be pursuing protected activities under the FHA, which are actions to protest discrimination. Specifically, it's actions to protest discrimination. So even if we want to get outside of the idea of lawsuits or complaints with HUD or anything like that, it has to be acts that are protesting discrimination that the defendants in this case would be retaliating against. And nothing that Mr. Goldberg has stated today, nothing in the pleadings shows that any of the actions that the plaintiff took were in defiance of discrimination. Instead, it's maintenance requests. And I think Mr. Goldberg, respectfully, I believe, is conflating the issues here, because the law is clear that it must be a protected activity, and it must show that that retaliation, alleged retaliation, is causally connected to that protected activity. Additionally, just to also clarify the facts, because we were looking for Mr. Leslie's affidavit, the ledger is very clear. And as I showed earlier, and I'm happy to show it again, there was one missed late payment in October that was not refunded. That was the only one. Mr. Goldberg stated, and I believe in the deposition testimony, there was apparently a late fee in December. But as I stated earlier, that's because the payment bounced back as non-sufficient funds and it was never remedied. And of course, late fees are going to begin accruing at that point. And Mr. Leslie even agreed in January through a consent order that he had failed to pay rent in a timely manner in December. So any late fees accrued in December were not retaliatory at all for any of Mr. Leslie's requests or actions. So we believe that the law is very clear that summary judgment should be issued to defendants on this issue, because Mr. Leslie failed to uphold his burden in this case to support the factors of the retaliation test.
Wilson is the case you highlight, which, as we discussed, is a Southern District of New York case. And yes, it relies on a Second Circuit case. Is there anything in Georgia state law or 11th Circuit law that says, look at Wilson, or more importantly, to the argument you're making, Ms. Livingston, that protected activity for purposes of an FHA retaliation claim is activity to protest discrimination?
I don't have any on hand, Your Honor. I'm happy to supplement, but I would like to point out that the case that Mr. Goldberg cited to, which was, I believe, an 11th Circuit case, I've now lost it. But that actually was not granted to the plaintiffs in that case. The plaintiffs also failed to show a retaliation claim in that case. So even if, benefit of the doubt, the actions that Mr. Leslie claims he was taking were protected activities, there still is that second prong. The action, the retaliatory action, has to be causally connected to that. And it is clear that the evictions in this case, that the late payment or the late fees in this case were all because the plaintiff failed to pay rent in a timely manner pursuant to the terms of his lease agreement with the defendants. There's no evidence in the record that any of these actions were retaliatory for any of Mr. Leslie's requests.
Well, I hear you on that, but I also hear Mr. Goldberg that we're getting into proximate cause. What explains why the defendants did certain things? I am much more focused on what qualifies as protected activity. But I'll get to the bottom of that. You guys have both given me some thoughts on that front. Let's turn to the Fair Business Practices Act claim. And then we'll do negligence. And I think that's what we're going to have time for today, since it's already 1:20 or so.
Absolutely, Your Honor. Okay. So again, there's a prima facie case that must be presented to bring a claim under the Fair Business Practices Act, and plaintiff failed to present a prima facie case for this claim. Pursuant to Regency Nissan Inc. versus Taylor, which is a Georgia Court of Appeals decision from 1990, for conduct to be actionable under the FBPA, it's a two-pronged test. First, the court must determine that the particular activity occurred in the conduct of consumer transactions and consumer acts or practices. And the second is whether that act or practice in issue is unfair or deceptive. Of note, first and foremost, the Georgia Court of Appeals was very clear in 2005 that claims under the FBPA must harm the general consuming public, and it should not be treated as an additional remedy for private wrongs. And that is what the plaintiff is attempting to do in this case. He's attempting.
But you say that, but let me interrupt you here, because I didn't have a chance to look at the cases since we started, but Mr. Goldberg was pretty adamant that there is Georgia case law that says landlord-tenant relationships qualify as consumer transactions, consumer acts. Assuming that's true, and I'll let you rebut it in a minute if you think that's not correct, then why wouldn't that be something that Mr. Leslie ought to be able to pursue? Yes, the alleged discrimination was your client versus Mr. Leslie, but if your client is purportedly engaging in discriminatory practices as to Mr. Leslie, that affects anyone else who might be suffering from a disability and is seeking reasonable accommodations at this apartment complex.
Well, two things, Your Honor. First is that if plaintiff is basing this on his fair housing discrimination claims, we believe the evidence is clear that there is no discrimination in this case. Therefore, there's no Fair Business Practices Act claim. Second, there's no evidence in the record at all that these actions by the defendants toward Mr. Leslie are at all part of their general practice. And that's the whole point of the Fair Business Practices Act, is that it has to be the general practice of the proprietor in that case toward the consuming public for it to be an action that occurs in the conduct of consumer transactions. And so even if Mr. Leslie is trying to allege that, he presented no evidence to that effect, that this is within the general practice for the defendants to be discriminating against anyone. Additionally, the Georgia Court of Appeals in 2005 in Brown versus Morton held that breach of contract claims are not a violation of the Fair Business Practices Act. And the court also held in 1991 that private agreements to alter general practices, such as a request for reasonable accommodation in this case, cannot be considered consumer acts under the FBPA because those are private agreements. The plaintiff presented himself to defendants, asked them to deviate from their general practices and provide him with a reasonable accommodation. So that's a private transaction, not within the occurrence and conduct of consumer transactions, as is required for an FBPA claim.
Okay. Did you have anything else, or you've?
Oh no, I'm sorry, Your Honor. That's all on this point. We believe that because the plaintiff did not uphold both of the required elements of this claim, that we are owed summary judgment on this issue as well.
All right, Mr. Goldberg.
Your Honor,
you and I have already talked about this some. Anything you want to add?
Your Honor, I will simply add that the unfair business practice in the Stringer case that I cited to Your Honor was a wrongful eviction. And there was certainly no proof that the landlord went around wrongfully evicting people as part of his general practice. What makes this different and makes it more than a private transaction between two parties is the discrimination effect and the public policy of the state and of the federal government. They haven't distinguished the landlord-tenant case I cited, and they didn't even discuss the federal case I cited, where legal aid brought a case that survived a motion to dismiss under the Fair Housing Act for redlining and under the Fair Business Practice Act. So again, this is up to the jury.
If I may say one thing, Your Honor.
Yes, ma'am.
Respectfully, Mr. Goldberg continues to say, well, this is all up to the jury, but each of these three claims so far are all based on the plaintiff must present a prima facie case for each of these claims. And so it's not up to a jury if there's no evidence in the record supporting even one prong of each of these tests. And the Fair Housing Discrimination, Retaliation, and Fair Business Practices require the plaintiff to present evidence to support any of these claims. It's not even that evidence is in dispute. Plaintiff has failed to show how this is a consumer transaction or occurrence, and he's failed to show that it was unfair or deceptive.
Well, that's where you all disagree. I don't think it's a question for the jury, and it's not what Mr. Goldberg said, whether this was a consumer transaction or not. That's a legal question, and I'll just need to look at these cases. But the cases aren't aligning right now, and I will look more closely at them to see which cases are more controlling. Certainly a Georgia case is going to control more than a Fifth Circuit case if that's what's on the other side. But I'll have to dive deeper into that. Okay. Then let's talk about negligence and the storage shed.
Absolutely. So again, plaintiff failed to uphold his burden of proof that defendants were negligent in this case. And just as a reminder, I wanted to reiterate the facts surrounding the alleged storage unit burglary. Again, the defendants obtained ownership and management of the property on July 23rd in 2019. The only evidence in the record of a storage unit break-in besides Mr. Leslie's was an August 22nd, 2019 storage unit break-in. There were no other break-ins, and on October 3rd, 2019, the defendants installed an on-site police officer. And again, there were no other break-ins until plaintiff's alleged storage unit break-in on December 31st, 2019. Now in Georgia, a proprietor is insulated from any liability of third-party criminal attacks unless that act was reasonably foreseeable. And that reasonably anticipate criminal action by a third party. When defendants are on notice of criminal action and that superior knowledge, it's based on prior criminal acts on the property. And that's under the authority of Now versus Quality and Inc., which is a Georgia Court of Appeals case from 1987, which held that a hotel operator was not on notice of heightened danger, despite the occurrence of 25 crimes on the property the previous 4 years, because the crimes were not substantially similar in nature to the injury litigated. Additionally, in 1991, the Georgia Supreme Court held in Laus Corp. Inc. versus Haskins that a plaintiff failed to uphold their burden of proof in presenting any evidence that conditions of a parking lot where an injury occurred fell below reasonable security standards. And in that case, the plaintiff failed to present any evidence that lights weren't working, that shadows allowed criminal activity, that other proprietors had hired security measures that were heightened. These cases show that it is a plaintiff's duty to prove that defendants had a superior knowledge of these third-party criminal attacks and this danger in order to be liable legally to the plaintiff. And that's why this is a question of law in this case, because the facts as plaintiff has presented them do not prove at all that the defendants had a heightened notice and a superior knowledge of criminal activity that may occur to his storage unit. As you can see from this timeline, there was only one storage unit break-in before plaintiff's alleged storage unit break-in. And as Nal explained, even 25 crimes, if not substantially similar, were not enough to put a proprietor on heightened notice. And additionally, there's no evidence in the record, and I stated this earlier, that plaintiff's storage unit was not locked appropriately, that he was afraid that crimes would occur in the vicinity of his storage unit. There's nothing that he notified defendants of to put them on a heightened notice that they needed to make sure that his security unit was safe from third-party criminal activity. And because
so what is your understanding from the record and the review of the depositions? Why did Mr. Leslie want to talk with Mr. Hurd about the storage unit? This is before the burglary, as I understand it. Hey, let's have this conversation about it. And according to Mr. Goldberg, Mr. Hurd said, we'll look into it, but Mr. Goldberg doesn't want anyone to believe Mr. Hurd. So that was all a ruse or whatnot, and nothing was done. But what was the point of bringing the two? Why did Mr. Leslie want to talk about the storage unit pre-break-in?
According to Mr. Leslie's own deposition testimony on page 26 of that transcript, he stated that it was for mere peace of mind. He stated he was going out of town and that he wanted a metal plate to ensure that his storage unit was extra secure. He never indicated to Mr. Hurd, according to his own deposition testimony, Mr. Leslie's, he never indicated to Mr. Hurd that he was afraid of criminal activity because of a prior break-in, that he'd seen anyone trying to break into his storage unit. He merely said, I'm going out of town. I'd really love an additional metal plate on this door just for my own peace of mind, which according to case law and according to Georgia precedent, does not put a defendant on a heightened notice of third-party criminal activity to which they owe a duty to the plaintiff.
Nor was this anything to do with a reasonable accommodation, which was my misunderstanding of how Mr. Leslie was originally arguing things. So I get that. Okay.
Correct.
All right. So Mr. Goldberg, I agree with you 100% that proximate cause is typically the exclusive province of the jury, but there do seem to be some threshold legal hurdles that Mr. Leslie needs to clear. How does he clear them if the record is that there was only one prior break-in, and this is not, again, my earlier misunderstanding of the state of the record. This is not a situation where like the door to Mr. Leslie's storage unit was broken and my little kid could open it just by tugging on it.
Your Honor, the first way he clears it is that we go to the right statute and not the one that she cited. In her brief, she cited OCGA 51-3-1. The correct statute is 44-7-14. The landlord is responsible for damages arising from destructive construction or for damages arising from the failure to keep the premises in repair. And I would refer, Your Honor, to a case called Warner versus Arnold at 133 Georgia Appeals 174 at 179. He brought this to the attention. He said he needed more security. And I just want to read you part of this deposition, Mr. Hurd, and you'll see what I'm talking about. Now, when he took you down to the storage unit, I'm sure he told you he had some problems with the security of the place. Isn't that what he told you? Answer. He said something with the lock. I can't remember verbatim. The words lock and security don't kind of go together in your head. I just remember lock. The reason people have locks is to provide security, right? I don't know, but I'll answer your question. He just told me about his lock. Sir, I'm sorry, hold on a second. You don't know that the reason people have locks is to provide security? Answer, I can't speculate on everybody else. Now,
All right, I'm more interested in what Mr. Leslie recalls about it. I suspect Mr. Hurd is interacting with dozens of tenants every day, and his lack of complete recall of what Mr. Leslie told him months before, not remarkable. I appreciate the point you seized on, but you and Mr. Hurd didn't get along well. What is your claim Mr. Leslie said in his deposition about why he wanted attention on his unit? Was it because there was a defect in the storage locker, or he wanted additional security? I appreciate 44-7-14, but I don't understand that to be the allegation. I just asked you, is this the kind of case where the door didn't work, and so the risk was not that risk could be just that the door pops open and then someone can get in his unit?
Your Honor, I think the answer is that he thought that it wasn't safe enough, and he was asking for a deadbolt or a security plate. Okay?
Well, what does that mean? What is safe enough? It'd be great to have one of those guys with the big black furry hats and the red jacket from Buckingham Palace standing in front of his unit. That would make it safer. Because they didn't do that, are they negligent?
Your Honor,
it's not a jury question.
Your Honor, in this particular case, he had already had his lock. We already agreed that he has an earlier break-in. So this isn't like
earlier break-in at this apartment complex?
I believe it is at this apartment complex, but before these people took over, okay?
The one where the same things were stolen, or is that a different apartment complex?
Your Honor, I think it's the same.
It's not. Your
I'd
Honor.
It's a different county. It's a different jurisdiction, different county.
Then, Your Honor, I misspoke, and I apologize to the court. But the police report said that he noticed that his unit, along with two other units, were broken into by removing damage in the lock and door handle. And that's defendant's. I'm sorry,
Ms. Livingston, wait till he's done. Keep going.
That's defendant's Exhibit E, and that's what the police officer said.
It's what the police officer said. Mr. Leslie said.
I think that the police officer is writing what he noticed.
Okay, I'm asking you because I thought you said the police report said that he said. So is the police report an exhibit to what? I just soon read it myself.
Your Honor, it's defendant's Exhibit E.
Defendant's exhibit. All right, let me get my hands on that.
Okay. Your Honor, as to what he specifically said, I can't tell you at this moment. I could tell you within a day, and I'll just send you something if you don't mind, and I'll give you the citations.
Okay. But let's get back to the question, which is whether it's 44-7-14, which would seem to apply only if the apartment complex failed to maintain, and if the same locks were everywhere and no one else was having issues. I don't know that it's a failure to maintain. And if there's no allegation or any evidence that there was a failure to maintain, I don't know that that's the right statute. But even if you're correct and it's the right statute, tell me why the cases that Ms. Livingston was talking about don't control this in terms of superior knowledge and what duty, if any, the apartment company owed your client.
Your Honor, they don't control because they're interpreting a different statute.
Okay.
A different statute is not a landlord-tenant statute. 51-3-1 is not a landlord-tenant statute, and it doesn't control in landlord-tenant cases. There's a different standard of proof.
Okay, Ms. Livingston, talk to me about that. What's your thought about that?
So Mr. Goldberg is citing to 44-714, which is liability of out of possession landlords to third persons, licensees on the property. And we're referring to Mr. Leslie as an invitee, which means that it is the statute we cited to, which does control, in the case law that does control for a landlord's liability to an invitee for third-party criminal attacks. So the law that we are citing is on point for this issue. I do want to go ahead. I pulled up the portion of the deposition where Mr. Leslie states that there was no problem with his unit, which means the defendants had no superior knowledge of any third-party criminal attacks or theft.
Well, and so let's see that, because I want Mr. Goldberg to process that for me, because then I don't think it matters what statute we're looking at. If Mr. Leslie's deposition is my unit was fine, I just need more. Then I need explained to me how that makes the landlord negligent under any statute you pick.
Absolutely. So it's here on page 93 of Mr. Leslie's deposition, line 16. I asked, was there any problem with the unit prior to this, or was this just added security measures you wanted? He responded, I don't recall if there was much wrong with it prior. I just, before I left for my own comfort, I wanted the extra plate or deadbolt on the door.
Okay. So assuming there's not more out there, Mr. Goldberg, tell me why we would continue to talk about negligence after I resolve the motions for summary judgment.
Your Honor, I'd have to look at it further. I can't give you an answer to that right now.
Let me ask it a different way. If it turns out that that excerpt we just heard is the sum total of Mr. Leslie's presentation on why he engaged Mr. Hurd and why he wanted there to be work done on his storage unit, would you agree that summary judgment is appropriate as to the negligence claims? And if not, why not?
Your Honor, I don't think I can answer that question. I mean, I'd have to go back and look at it. I'm inclined to tell you I would agree with you, but I'm not going to commit myself until I go back and look at it.
You're not committing? I asked you a hypothetical.
Then hypothetically, I think I would agree.
Okay. So your job, should you choose to accept it, is to find other things in the record that expand upon Mr. Leslie's explanation as to why he wanted something done to his storage unit. And not, hey, my old one got broken into, because I don't think that would get you over the hurdle as well. It would need to be, my unit is somehow defective as opposed to the others, not I want special treatment and I want something on mine that aren't on the others. So I think if it's just I wanted something more because that would make me more comfortable, I don't think that gets you past summary judgment, but you will look into it. I am confident.
Your Honor, could we both have a week to, add to whatever we said today? I don't know if I'm going to get it to you in the next few days, but I will certainly get it.
We'll talk about scheduling in a minute, but the answer is yes, you can have time. I'm not going to jump on this between now and Wednesday.
Okay.
Too many moving parts to have gotten through that.
Your Honor, if
All
I
right.
could clarify one more thing briefly.
Yes, ma'am.
Just for also Mr. Goldberg's edification, I want to clarify that he's looking at the incident report. The attachment you're looking at, Mr. Goldberg, is the Sandy Springs, or excuse me, the incident report from the 2017 burglary that you were citing to.
Yeah,
Do that again. Do that. I'm sorry. I heard parts of what you said, but I didn't hear you completely, and I apologize.
So the police report you were reading from is the police report from the other break-in that Mr. Leslie had, the earlier one in another county, when he said all these things got taken from my unit. So the police report says what you said it says, wrong incident. That is not the police report from Sandy Springs, and the defendants, Mr. Leslie, is suing this time around when allegedly the same things got stolen when his unit was allegedly broken into again. So just make sure those wires don't cross when you are getting back to me about the negligence piece of this one.
Thank you, Your Honor.
All right. I think that covers the four main areas of your motion for summary judgment, Ms. Livingston. Was there anything else you wanted to cover in connection with that?
No, Your Honor, just that this was essentially a case that's blown out of proportion from just simple lawful evictions for non-payment of rent. And the plaintiff has failed to present prima facie cases for these claims and failed to uphold his burden of proof.
Okay. Mr. Goldberg, I feel like by having the back and forth that we've had for defendant's motion for summary judgment, we covered the parallel arguments that you set forth in your motion for partial summary judgment, or partial motion for summary judgment. I don't know where we put the partial, but I don't want to make the wrong assumption there. Were there arguments that you wanted to make today in connection, not with defendant's motion, but with yours, that you have not had a chance to do during our time together so far?
Yeah, I think I've gotten out what I wanted to say. And I'll rely, if I haven't, my briefs will do the speaking for me. But okay. I believe I have gotten it out.
I think so too, just because I viewed them as what you were arguing against in your brief in opposition to defendant's motion, you were arguing for in your motion for summary judgment, and vice versa for defendants. So Ms. Livingston, let me ask you the same question. Was there anything that you were prepared to argue in opposition to Mr. Goldberg's motion that you didn't argue when you were arguing in favor of your motion?
No, Your Honor.
All right, good. Well, it is 1:45 and I need to wrap up. I know we did not talk about the motion to compel rent payments or well, let me do this. I would like to hear from you, Mr. Goldberg, if you prepared for it. I don't know. I think the notice that Ms. Niles sent out was be prepared to talk about everything. If that's not how you interpreted it, I'd like to hear your thoughts as to why I ought not to compel payment of rent for the many months that your client was there and wasn't paying.
Your Honor, I am prepared to talk about that. Although I must note, I think Ms. Niles said that this issue was not coming up, but I am prepared. Your Honor, when they filed the motion for the second time, and the first time they had filed it in federal court, it was not ruled upon. They referred to the landlord-tenant statute, and I discussed why it was frivolous. It was frivolous because they had not filed any counterclaim for it. They had not asked this court for permission to add a counterclaim. It's after the pretrial order. And the statute that they relied upon did not provide the relief that they were talking about. I believe it was 44-7-10 or 14, Your Honor. When they received my response, they filed a reply that said equity, equity, equity. And that was, I believe it was on Thursday or Friday of last week. I will simply point out that they're not entitled to equity because they haven't shown that they don't have an adequate remedy at law. They don't discuss that. What they can do, it seems to me, Your Honor, is they can do what anybody else who has a judgment can do in this particular proceeding. They can do a garnishment. They can levy on his property, levy on his personal property, but they're not entitled to this relief. They haven't shown that they lack a remedy at law. All that stuff about landlord-tenant law that they put in their first brief is just wrong. And I pointed out that one of the things that my client argued in federal court, and again, none of this was ruled upon. In federal court, the judge dismissed the case because of lack of jurisdiction. So none of this was ruled upon. But what he was arguing in federal court was that he had a witness who saw the defendants in this case remove his property from that house. I'm sorry, the apartment, Your Honor. Now, we haven't, that, as far as I'm concerned, that's not part of this case. But it would certainly be a defense if we were going to argue about paying rent into court. And he doesn't live there. Now, if he lived there and he wanted to stay there and they had filed a dispossessory, they'd file a motion to pay rent into court. But even in a dispossessory, if they filed the motion to pay rent into court and the tenant refused to pay it, what would happen would be that the tenant would have to get out of the house. The court would not order him to pay rent into court if he wasn't living there. And right now, he's not living there. So we have all these issues. They bring it up late. They haven't brought it up as a proper counterclaim. We have issues that remain. We've already done a pretrial. They delayed this trial once on a 635-page motion for continuance of 2 pages. I'd like to get to trial, but right now they're not entitled to it. They have not shown that they lack an adequate remedy at law. Now, I didn't argue that point in my brief, but I certainly argued the other points. And as I pointed out in my brief, they don't have any res judicata or collateral estoppel effects from federal court because this case was dismissed for lack of jurisdiction. So I think it's not a proper motion. For it to be a proper motion, they'd have to file a counterclaim. They'd have to ask for your permission. And we'd argue about whether or not it's timely, but they haven't at any time. You know, they're claiming that rent is due back months ago. And as near as I can figure out, they're claiming that it's due for over a year. They're claiming they have judgments for a year, and they haven't bothered to file a counterclaim. And they haven't bothered to file anything that says they should be able to file a motion. They should do what any other creditor who has a judgment should do. They can garnish. They can garnish his bank account. They can levy on him. But they haven't shown that they lack an adequate remedy at law. And therefore, under any theory they want, whether it's landlord-tenant, 44-7, whatever it is, 14, or just equity powers, they got to have some kind of pleadings to ask for the equity. And they don't have those pleadings.
All right. Ms. Livingston, what about Mr. Goldberg's argument that really this is a counterclaim and it's a little late for there to be a counterclaim? And were there other channels through which your client has pursued this back rent? Answer that, please. And it is a slightly different situation than what I typically see when there is an effort by a landlord to get rent paid into the registry, because that's what you're asking for. You're not saying give it to us. You're saying put it in a safe place so that when the dust settles, if the correct answer is back rent needs to go to your client, Ms. Livingston, there's a way to get it there because it's in a safe place. So I get that. But that's what happens when the tenant is still there and the tenant's not there. So this seems a little different, both chronologically coming after pretrial orders in place, et cetera, and just situationally because Mr. Leslie is out of your client's unit. And I know you don't want to relet it because you're worried about wrongful eviction, but I don't know that that's Mr. Leslie's problem right now.
Yes, Your Honor. So first, Mr. Goldberg, respectfully, he misrepresents our pleadings. We are not actually asking for back payment of rent. What happened was on March 25th, 2021, the corporate office of the apartment complex completed the landlord portion of emergency fund request for Mr. Leslie. And we found out from Fulton County that those funds were dispersed on August 15th, 2021.
All right, you mentioned this. I'm sorry to cut you off, but that this is, look, that Mr. Leslie is somehow, my term, and I don't mean it pejoratively, but sort of double dipping. He got this place to live in for free, and then he got money to pay rent that he basically wasn't being required to pay because your client, Ms. Livingston, decided, well, we can't evict because it's COVID, but we don't want to accept rent because that would suggest we have an ongoing business arrangement with Mr. Leslie, and we don't. And yet Mr. Leslie got rent relief.
Yes,
And if
Your
that's going to
Honor.
go anywhere, it ought to go to your client.
Yes, Your Honor. And it's not necessarily categorized as a back pay of rent. This is just what Fulton County decided to issue to Mr. Leslie. For some reason, these emergency funds are not directly given to the landlord, and it was given to Mr. Leslie to give to the landlord. These funds are specifically designated to the defendants in this case by Fulton County. And it was
Sure.
after dispositive motions were filed, and there was no way to go and make a counterclaim because this came up just recently in October.
Well, I don't think this would just fall in Mr. Leslie's lap. I think he'd have to apply for it and query whether, I'd love to see what he put in his application, but I'm sure I can get that if I ask his lawyer for it real nicely. So, Mr. Goldberg, with that gloss on it, why isn't the right thing to do to put that money from federal, state, and local agencies that went to your client for rent relief when he wasn't paying rent? Why shouldn't that go into the registry of the court till we figure out what ought to happen with it? Because these are all events that occurred after the pleadings were filed, et cetera, and maybe after the pretrial order was entered. I don't know the exact timeline, but it's not back rent. I mean, that would be the defendant's basis for claiming it, but the money came from Uncle Sam or Uncle Kemp for rent relief for a guy who wasn't paying rent.
Your Honor, however you wish to characterize it, there is no claim for that. And a motion is not a claim. That's the first thing. Second thing is, to the extent that they're asking for this court to exercise equity power, they haven't shown that they don't have a remedy at law. In fact, they don't even discuss it.
How did Mr. Leslie get the money?
My understanding was that at first the defendants blocked it, and then he got the money. And I don't know, beyond that, I can't tell you. I know that it was blocked at the first because he was supposed to pay me at some point, and he said he didn't have it because they had blocked it. Now, beyond that, I don't know whether or not he went down there and got it, or they handed it to him, whether they mailed it to him. I just don't know the answers to those questions, Your Honor.
Okay,
But-
I asked my question poorly because you did. That's not what I meant, though. And I don't want to prevent you from getting paid for all the work you've done. But what I meant to ask was, how was it that Mr. Leslie ended up being eligible for and receiving rental relief funds when he was paying no rent?
Your Honor, I think the answer, let me phrase it this way, Your Honor. I have not seen what the application looks like, okay? So you're getting an answer from a lawyer who hasn't read the one document he's supposed to have read.
Me
But
neither.
I don't know that they asked that question, are you paying rent? And so
Okay.
I think the answer was that, that he asked for rent relief because, he is living at another place, and he's been living at another place even before he got this check. So it isn't like it's their money. He's going to use it to pay the rent at the place that he's living in. But again, Your Honor,
I mean, you are arguing appropriately some procedural hurdles that you contend the defendants didn't clear. It's not a claim, it's just a motion. And there may be redress at law before equity needs to step in. So I need to work through those arguments. That's helpful. It was also helpful to hear from Ms. Livingston, hey, this isn't back rent that we claim we're owed, and so he just magically ought to put it in the registry. But we, defendants, came to learn that Mr. Leslie presumably had to say, I am in great need for rental assistance during the period of time when I'm paying no rent to live in the defendant's apartment. And if he received money in connection with that, equity would suggest that it go to the defendants and not to Mr. Leslie. But it may be that equity ought not to reach into that pot because of where we are, these two parties, and this court procedurally, and I'll need to work through that.
All
right.
I'm going to make one more significant point on this.
Yes, ma'am.
First, obviously, our briefings will speak for themselves as to the legal and equitable reasons that we're owed to this money to be at least put into the court registry. But first of all, it was an application that was filled out by Sink Residential on the landlord side. So those funds are meant for Sink Residential and not any residence where Mr. Leslie currently resides. And secondly, these are from the Fulton County Emergency Rental Assistance Program, and it is for rental assistance. And Mr. Goldberg has now just represented these funds were supposed to be paying his legal fees. So we definitely want to make sure that this money is put in the court registry so that the plaintiff is not spending rental money on things that are not rent fees.
Or for rent at a place for which he didn't apply.
Correct.
Okay. Well, this is a whole other can of worms. It may be I decide that's a problem for another judge because it's not properly before me, but I'm certainly going to think about this one as well. We need to wrap up, and I am happy to give both sides, what is today, the 6th, until the 13th to file anything 10 pages or less that supplements what we talked about today. Because you all have briefed it well. I clearly have some cases I need to read. But if there were questions you were asked that you'd like to answer more fully in writing, or you believe that I continue to labor under a misapprehension of either the facts of the case or the law that ought to apply to it, I invite you to help me out with that. And so you don't need to file anything at all if you don't want to. And it can be as simple as an email to Ms. Niles and obviously the other side with 2 case citations. Read these 2 cases and you'll be where you need to be. But it can be more involved with that if you want. It is not an assignment. It is an opportunity if you want to seize that opportunity. I will take all of this under advisement on or after the 13th. And if there are parts of the issues before me that I think are pretty clear cut, I may have Ms. Niles send an email out to both sides saying, look, the judge is ruling this way on this issue, but the party in whose favor he's ruling gets to draft the order to that effect. And that would be a proposed order. The other side could weigh in, not to try to persuade me to rule in the other direction, but to say, no, that's not quite the right fact, or that misrepresents something, and I'll consider those proposed edits. But you may not hear from Ms. Niles. This may be one that we keep in-house and draft here. Mr. Goldberg, any questions about what we're doing next?
No, Your Honor.
Well, I appreciate your time and energy that you put into this. Ms. Livingston, anything else on behalf of your clients?
No, Your Honor. Thank you.
All right. Well, thank you to you and Ms. Leray for your efforts, and we will be in touch. Let me make sure. Ms. Niles, anything else? I know we didn't talk about the motion to strike, but that's because we're out of time. And I will look for anything else by the 13th, and then we'll move forward.
Your Honor, thank you for your patience and time.
Not a problem. Thanks, everyone. And you all will take care of Mr. Almakinder. I don't know who arranged for him, but if you're splitting it, make sure you take care of Veritext and Mr. Almakinder.
Your Honor, this is Felicia Leray. I just wanted to take an opportunity to thank you for the time and attention you spent to this matter. You've given us an extraordinary amount of time to fully brief the facts and law in this case, and we sincerely appreciate it. I think you ran an excellent court today, so I just wanted to chime in and let you know that.
Well, thank you. It was a little more time than I intended, but Ms. Niles hinted that this was a complicated one and it wouldn't make a lot of sense to limit it to 20 minutes per side. So thank you, everyone. We'll be in touch.
Thank you.
So,
Going
Mr.
off the record,
I was,
we're off
you need to
the-
say.
we are off the record. The time is